is going to be recorded and it will be available on a YouTube channel, Garden Court YouTube channel, and there'll also be any slides and material that's discussed during the seminar will be available afterwards. We've decided to select 3 elements of the bill of particular concern, and in this order we're going to address those parts of the bill. So first we're going to hear from Jude Lanchine, who's going to speak about the serious disruption prevention orders. Secondly, then Tom Wainwright is going to look at the measures relating to disruption on the roads and infrastructure, prohibitions on tunnelling and locking on, Elena on stop and search powers and their impact in particular on Black and racialized communities. And then we'll follow up finally with Kevin Blowe from Netpol, who's going to speak about the wider context to put this in its social reality and what might be next in terms of activities in response to this legislation. So in the usual way, we've got both a chat and a question and answer section. If you've got questions, if you could put your questions into the Q&A. Unfortunately, Jude can't stay with us right until the end. So if you do have any questions for Jude after her talk, feel free to raise them then. Everyone else will deal with them at the end and take them all in one go. So as I said, we're going to start first with Jude. Jude is probably very well known to you, highly experienced criminal practitioner at Bindmans, who has a wide-ranging criminal practice covering serious crime, specialist representation for young people and youth justice, but she's also very well known for her work on public order and protest cases. And the particular topic that she's going to cover, as I've indicated, is parts of the legislation that seek to introduce measures that were rejected in the previous bill, that's serious disruption prevention orders. So over to you, Jude.
Thanks, Steph. Good afternoon, everyone. I do apologise for not having a little slideshow, but the others do, and it will assist you if I let you know that all of the law that I'm going to refer to is in clause 12. And I'm not going to speak at a slow pace for everybody to write everything down because you can find it there. Can I echo, starting, everything that Steph has said? This has not yet gone through Parliament fully, and of course it hasn't got to the House of Lords yet, but I think all of us fear very greatly that it could well, in some shape or form, or even in the form that it's in at the moment, end up as law, and probably not in too distant a future. A serious disruption prevention order. Wow, what is that? Well, the law is there, but it's actually not that clear, as of course is often the case with many of these types of legal provisions that try and prevent us, and I say myself as well as others, from taking part in lawful and, for most of the part, peaceful protest. An SDPO applies to people over 18 who are convicted of an offence committed on the day or on the day after that it comes into law. And it can be made, this is where the first big red flag sticks out, if a court is satisfied, quote, on the balance of probabilities, not the criminal court or offence standard that we're used to, that the current offence is a, quote, protest-related offence. So if you go to the law and you then look at interpretations and you look at what a protest-related offence is, I'd like to tell you, because no doubt you are all waiting to hear that, and I will find it in the relevant section. A protest-related offence means an offence which is directly related to a protest. So circular. Who knows what directly means? There is no definition of that. And who knows exactly, in many ways, what a protest is? Of course, we have a living example in recent memory of the Sarah Everard situation. Some people might call that a protest. Other people would have called that a vigil. Other people might have other terms. Who is to say what is and isn't a protest? There are obviously many situations which are clearly protests, but there can be many others, as no doubt you'll understand. And Sarah Everard is just one example of those which might be people who are marking the death of somebody. Perhaps the family of Chris Cabba, who was shot by the police just recently. They and other people might be outside the area he died where there are flowers, with hymns or with speakers or with whatever. Who defines what that is? And what does directly mean? So that's the first red flag, and we've only literally got about 5 lines into clause 12, of which is the section dealing with these orders. The second category or second criteria by which the court has to find that this has been or has occurred is the conditions, if those conditions in subsection 3 within the relevant period, the court is satisfied again on the balance of probability that the relevant person has either committed another protest related offence for which he or she was convicted. And again, already there's a red flag there, because it may be that the first offence came during a period when this law wasn't in, or perhaps on the cusp of it. Secondly, has committed a, quote, protest-related breach of an injunction in which the person was found to be in contempt of court. Again, what exactly does that mean? Or carried out activities related to a protest. Again, we have related to a protest, question mark, what does that mean? That resulted in or were likely to result in serious disruption, the key phrase, not defined, to 2 or more individuals, to only 2 or more people, or to an organisation in England and Wales. Wait for it. This section is now about people who don't even have to have done something themselves. Subsection 4, caused or contributed to the commission by any other person of a protest-related offence or protest-related breach of an injunction. Or, and again repeating the earlier part, caused or contributed to the carrying out by another person of activities related to a protest that resulted in or were likely to result in serious disruption to 2 or more individuals or an organisation. So there you can see quite starkly straight away that you don't even have to have allegedly done anything yourself to be caught by this proposed legislation. Caused or contributed, again, not defined. What does that mean? Does that mean preparing a banner that somebody then, which you didn't know, used to wave about and or allegedly, throw in the direction of a police officer, drop them off, prepared and helped for other things that were connected to the protest? Again, we're back to directly related as well, because it's all entirely circular with no definitions, but you can see the scope. Or drove people down in a bus, to a demonstration. I mean, we have no idea what any of this is going to mean, and it all remains to be seen in the courts, how the police deal with it. We fear, of course, like all of you, that it will be defined in the widest way possible, but it might be that the government have to put a certain level of brake on it, not to include within these non-defined definitions or words what they actually mean. The purposes, or the purpose of one of these orders, is to prevent the person subject to it from committing a protest-related offence or a protest-related breach of injunction. So through every single part of this section of the bill, all the same terms are used, and therefore, if nobody understands what they are, someone has put into the chat, someone publicising a protest on social media, encouraging others to attend. Who knows? I mean, it may be, for example, that in and of itself isn't court, but if, for example, there were conditions within that particular protest or what the issue was about that perhaps people ought to have known might generate people's I don't know, tensions rising, or something that might lead to a confrontation with the police, or for example, where it is to do with those that involve potential criminal damage. Obviously, Tom is going to deal with locking on, etc. Perhaps that those could be caught, defined almost, your involvement in terms of causing or contribution, almost defined by what the end result was. We don't know. We don't know what the mental element of any offence to do with causing or contribution might be, whether it's going to be something along the lines of it should have been foreseeable that there might have been criminal activities. I mean, everyone's guess is as good as mine. The purposes go on again in the same way: prevention of carrying out the activities related to a protest, and or prevention of assisting other people or encouraging or preparing, etc., any activities of other people. So it's all the same, repetitive. Now, the other interesting little thing that I found when looking through the Act is that in section 9, when the court is considering, on the balance of probabilities, again, very low threshold, whether or not to make an order, this section states it does not matter whether evidence would have been admissible in the proceedings for the main current offence. So clearly, this is in a situation where an order can be made attached to another matter, a criminal offence that is currently being heard at that time in relation to the defendant of whatever sort. It doesn't specify any type of offence. We therefore could be looking at very, very low level offences that don't even result in people going to prison, or have extremely low level penalties attached to them, or are imprisonable, but from prior cases that many people will be aware of, have often resulted in conditional discharges or low sentences. So no matter that material evidence might not be available, admissible within the substantive matter trial, it can be brought in as part of the, I would suggest, a kind of mini trial, to when the court considers whether to make an order of this kind or not. Again, nobody has any idea what that means, and there will always be arguments around admissibility in protest type cases, regarding the wider issues that might be at play in a particular protest, etc., whether or not something could be ruled as inadmissible that the defence might want to put in, and then ruled as admissible within the order hearing or attached hearing. Who knows? Somebody is saying, does the word serious give us any reassurance? I'm actually just looking at the comments because it might assist as we're going along. The answer to that is we don't know. There is no definition of what that means. Given that this bill is alongside other hugely contentious restrictions, for example, locking on and all of the other kind of stuff that other speakers will speak about, many people might consider that somebody locking on or gluing themselves to a building that is probably going to do more damage to the person themselves if they're not careful than the building might not actually define that as serious damage, particularly if an officer comes along and uses a bolt cutter or other means to remove a person. So it's anybody's guess, I'm afraid, and I'm sorry we don't have any answers at this stage, but that's because of where we're at. And I think we have to assume that serious could actually mean really quite a lot of what we might consider to be relatively low-level protest type activities, because if not, why would this be coming in? The mass protest that exists and which this must be designed to curb and to intimidate people, to bully people, is going to be about what people do already. We're not talking about blowing up things. That, of course, would be encompassed, but that is already covered by other criminal law, and it is not the generality of what people do. So we have to assume it's about what people do already. You will remember when the boat was in the middle of Oxford Street, and to his shame, Sadiq Khan, but others claimed that there was serious disruption to people going about shopping, moving about here, there, and everywhere. It was actually a load of nonsense, because I knew people who were down there and caught in it and who managed quite properly to go to whatever shops they wanted to through the back streets. But words like serious are thrown about all the time. And so I think we have to just assume it's going to be everything, potentially everything. Now, next red flag. Everything that I've spoken about at the moment is an order that is attached to a conviction for another criminal offence. However, there is also the proposal to make an order otherwise than on conviction. It's a standalone application that can be made by the police to the magistrate's court. And again, the conditions are are almost exactly the same, if not the same. And so I won't repeat them, but the criteria, what the court needs to find on the basis of a balance of probability, and so on. What isn't entirely clear is the criteria or the situation in which the police would be allowed to do this. But one can only imagine that it will be when possibly people have been in court and have not been convicted, or people have been perhaps identified from the forward intelligence teams, the FIT teams, or in other ways, attending demonstrations numerous times. Perhaps there hasn't been enough evidence for them to have actually ever been charged with something, but there's somebody who the police have identified as they should take some steps to stop them going to things. I mean, that might sound draconian to some people, and that I'm in some mad 1984 or whatever world, but and I am not paranoid about anything. I just look at the reality in front of us, as I'm sure all of us do. And you don't know, because the very fact that this is even a provision within the bill that it is not just attached to people who have been convicted clearly means that they are after people who have not been convicted of anything or have not been convicted in the relevant period, which obviously would mean from the start of this becoming law. So essentially, this kind of application could actually result in an order being made against somebody who have not committed any offence whatsoever, whether prior to the relevant period or not. Now, you can appeal, which I'm sure that you would be glad to hear, and I will just let you know how you can appeal. It's not anything particularly unusual. You appeal in the normal way to the court if an order is made attached to a conviction, and if it's not attached, if it's an order made without there being a conviction, then you appeal to the court, which would be the magistrate's court, to challenge it in that way. There are also provisions which allow, if the court does not make an order, for the person who made it, so that would be the police if it's a non-conviction order, or the prosecution if it's attached to the end part of a conviction, to appeal against the decision of the court not to make an order, so they can have a second go. And perhaps, who knows, we all know what the CPS are like. They might find themselves at the end of a case not having quite gathered together all the I'm actually thinking of examples as I'm talking. You can imagine a situation where the CPS have got themselves a conviction, they haven't quite got all the material together, the non-admissible material that they'd like to use to apply for an order. They make an application, it doesn't succeed because perhaps they haven't done their job very well. They go away and they gather together more material and they can have another go. Now, I'm saying that assuming that further material could be made available to the court on an appeal. No doubt that is the case. There isn't any real clarity, again, in the law as to how that would work, but that provision is there as a possibility for those who want the order to be made, have not found it, so have gone in their way. Now, I won't take up too much time because actually I know it's already nearly 6 o'clock. Very quickly, the provisions can have the impact on a person of presenting themselves to a particular person's particular place on particular days. So that could be a kind of reporting condition, to remain in particular places, a particular place, again, that could be like a residence, and to submit to electronic monitoring. I mean, it's quite shocking, actually. This might be a person who's been convicted in the relevant period, which I failed to mention, and I should, 2 or more protests in a 5-year period. That's a big period. 2 or more protests in that relevant period could have been quite small, and they could be subject to monitoring. They could have an effect on prevention, in addition, of participating in particular activities, having particular articles with them. Does that mean a banner? Does that mean a banner? Or using the internet to facilitate or encourage people to commit a protest-related offence or a protest-related breach of injunction, or to encourage people to carry out activities again. So the bill virtually imposes no limit on the requirements and prohibitions that can be included in the order, as long as a court, on the balance of probabilities, thinks that they are necessary for the purposes set out above. And again, the criteria of necessity, yes, that is there, but again, it's not defined and we have no case law as yet, of course, to even understand what that might mean in practice. There are further provisions about the electronic monitoring, etc., which I won't take up time now. The maximum period, it's minimum of a week, maximum 2 years. Although also they can be renewed for up to 12 months when they expire. I mean, I'm sounding incredulous because I've read all of this and looked at it all, but when I repeat it back to everybody, it just sounds so, I don't know what, draconian. Breaching any of the prohibitions or requirements of an order without a reasonable excuse, again, we don't know what that means, is a summary only offence, punishable with up to 51 weeks imprisonment. I don't know even what to say about that. Now, some of you may know that there was a joint committee on human rights which did publish a report on the bill in June, and they also looked at the orders, the serious prevention, disruption prevention orders, and in summary, and I'll just give you a quick rundown of the kind of comments that they made. They will be ones that Liberty have or would make, and no doubt all of us would make ourselves and other people involved. They state the requirements and prohibitions are very likely to engage the right to respect for private lives under Article 8, if they restrict where they can go and who they meet. Obviously, it has to all be proportionate. They'll also significantly be likely to interfere with Articles 10 and 11, restricting rights there. Also, there is a question of whether any of this could be balanced up under human rights law in terms of being in accordance with the law and necessary in a democratic society. I'll give you some further examples. Again, the real things that stand out, the key phrase, serious disruption, is not defined. Activities relating to a protest, what on earth does that mean? Does that mean fundraising? What is a contribution? And again, the terms protest-related offence, protest-related breaches, directly related to a protest. What do any of these mean? The threshold is so low that it looks from the bill in its current form as if anything and everything could actually be covered by this. There are many other things that I could say. I will just conclude by saying that this report concludes, and again, it would be echoed by all of us, that it represents, the orders represent a disproportionate response to the disruption caused by a protest. The police already have powers, which we all know, to impose conditions and to arrest those that breach. And their view is that it poses an unjustified threat to the right to peaceful protest. I could say things in a much stronger way, but I'll leave it there because I think the law just speaks for itself, the proposed law.
Thank you very much, Jude. There were a couple of points that were made in the questions were focusing on the position of legal observers and whether they might get caught as being support activity. And certainly there was problems in the BLM protests with the role of legal observers, and they were issued with fixed penalty notices, and there was a challenge about that. And I wondered if, given what you've said about how wide it is, the provisions, is there a risk here for legal observers?
My view is that there is, but particularly because we already know that this has happened without this law or this proposed law from BLM. And I think that there is a real question mark then. I mean, obviously, we will know more if, or perhaps I should say when, it becomes law or some part of it, and therefore it will be easier to have some sense of how people in that position could be affected. And I think we're going to be just having to, continue with our advice to people who demonstrate, to all of those around the edges of the demonstration, so that everybody is very, very clear. But I think it could be called, it could be. The other thing I just saw that somebody asked about legal aid. I mean, again, where it hasn't been made without a conviction, you know, that remains to be seen, but no doubt that, well, who knows? Given that is the breach of it is a potential imprisonable offence, you would hope that the paltry legal aid that does exist might be extended to cover those who are resisting or who are, you know, fighting just the first stage of it, let alone appealing. But it all remains to be seen.
And just one other point, obviously the focus has been on Article 10, 11 and Article 8 rights, but do we really here have to also be looking directly at fair trial rights and the compatibility of these measures with Article 6? Certainly the ASBO legislation, the orders that prevented football, people going to football matches who were going to be disruptive, Article 6 was a way in which the court did say those measures were not compatible and read them down and read in safeguards. Is that also going to be a big issue here, given what you've said about thresholds, about balance of probabilities, etc.?
Absolutely. Absolutely. In fact, it's even more relevant because, of course, football, etc., that's, you know, that's a lawful activity, but this is the right to protest. And, you know, we might be talking about very, very low level offences. I mean, very low level. You know, what if somebody just sprays a tiny bit of paint on a pavement? You know, that's criminal damage. Well, we just don't know, but I agree. Yeah, that's going to have to be a way around it, because all of us lawyers and people involved actively in protest are not going to take this, and everyone is going to have to find ways of very imaginatively trying to circumvent the width of these non-definitions, both in terms of their own activities when attending or helping prepare or whatever particular activity it is in relation to a protest, questioning what a definition of a protest is, and then lawyers, where that might fail and people are arrested, are going to have to be very imaginative and challenging around how to get this stuff dealt with in court.
Thanks very much, Jude. So I think now we are going to move on to Tom Wainwright. Tom is a leading protest lawyer working at Garden Court Chambers. He's been involved in many hundreds of protest cases, some of the most high profile cases that I'm sure you're familiar with. Recently, the Stansted 15, the Colston 4 case, Occupy Parliament movement, Extinction Rebellion, anti-fracking protests. He represented Caroline Lucas, who was arrested at an anti-fracking protest. Obviously, we know fracking is back on the agenda now, and that will inevitably result in more work for Tom and many other people. But what he's going to focus on today is the elements of the legislation relating to locking on, to disruption on roads, and to infrastructure, including by tunnelling. There were some questions in the chat about where the legislation is going through Parliament. I think they've been answered, but if not, Tom will probably give you a bit of an introduction to that. Tom.
Thanks, Steph. Yeah, just in terms of where it is, it's at the report stage at the moment, so it's yet to go to the House of Lords. But unlike last time, where these provisions were added as late stage, so the House of Lords can get rid of them, that doesn't apply here, as I understand it. So they may be able to tinker with it or delay it, but it's unlikely that they'll be able to get rid of them in the long run. There may be some back and forth between House of Commons and House of Lords, but if anything, if last time's anything to go by, they will do what they can, but the powers that they have are limited. So what I'm going to deal with is I think the substantive criminal offences which are created, and I'm sharing, hopefully everyone can see slides that will be circulated afterwards. So I'm going to rattle through these. Don't worry if it goes by quite quickly, because as I say, they will come round afterwards. And these really just to sort of set out the key provisions in the bill. Now, the explanatory notes to the bill when it was originally introduced is interesting reading, because it refers to the need for these provisions being because of recent changes in the tactics employed by certain protesters, for example, gluing themselves to buildings, blocking roads, tunneling under land. And the first question you may have is, well, is this a recent change in tactics? Well, let's have a look at the various offences which they're creating and the tactics which they are outlawing. Locking on, we see there is suffragettes locking on 100 years ago. This is nothing new. And the definition they've applied is that it's an offence for someone to attach themselves to another person, object or land, attach another person to another person, an object or land, or attach an object to another object or land. Questions which arise, what does attachment mean? What degree of attachment? Presumably emotional attachment, it's not going to be enough. It'll have to be physical. And one would have thought a degree of permanent, maybe temporary physical attachment, but something more than just sort of holding hands or linking arms. So there's got to be something more to it than that, you'd think. The act has to cause or be capable of causing serious disruption to a more individuals or an organisation in a place other than a dwelling. And the mens rea, the mental element, is that the person doing the attachment has to intend that consequence or be reckless to it, so foresee that consequence may occur. There is a reasonable excuse defence, and we'll see that throughout these provisions. Now, that's potentially going to be very important. People who've been keeping up with the case law will know that there's been a back and forth for a long time about whether Article 10 and 11 and sometimes 9 on freedom of belief can be used or taken into account in criminal proceedings. And by and large, the courts have said, well, if there's a reasonable excuse defence, then that's how those can be taken into account, although in Colston, they watered it down even then. So that's going to be an important provision if people are charged with it, to argue that this was a reasonable and proportionate activity, or that it, in fact, it's the other way around, that it wouldn't be proportionate to interfere with their right to protest. It's a summary-only offence, 6 months maximum. There's a linked offence of going equipped for locking on. So that's an offence to have an object in a place other than a dwelling with the intention that it may be used in the course of or in connection with the commission by any person of a locking on offence. Now, obviously, that can be very widely applied. It's not just bike locks or chains. We're talking about super glue or anything which can be used to attach one object to another. A paperclip probably won't cause serious disruption, but the mens rea obviously is quite high. It's got to be with that intention. And the maximum penalty for that is a fine. The next offence is tunnelling. And again, there we see Swampy 26 years ago at Newbury. These are not recent changes in tactics. And the courts and the police seem to have got by in the 26 years since then without needing to use any new offences. So it's now, or it will be, if this goes through, an offence to create or participate in the creation of a tunnel, if that is capable of causing serious disruption and the person was intended or was reckless to that consequence. And they've gone into quite a lot of detail defining a tunnel. A tunnel is an excavation that extends beneath land. Doesn't matter if it's big enough for a person to fit in, doesn't matter whether it leads anywhere. And an excavation created with the intention it will become a tunnel is to be treated as a tunnel. Whether or not it's the tunnel to which it's going to connect has been created, whether or not it's big enough for anyone to pass through. And essentially any hole can be a tunnel, is the upshot of this provision. And it also includes extending or enlarging an existing excavation, or altering a natural or artificial underground feature. So it wouldn't therefore apply to existing natural or artificial underground features if they are already in existence. That's not creating a tunnel. So if you can get some highly trained badgers or something to dig the tunnels in advance, you could go into those. And it doesn't apply to tunnels to the extent they're in or under a dwelling. Is interesting, potentially useful. Dwelling is defined quite widely and includes part of a building or structure. If that part's used as a dwelling, it includes any yard, garden, grounds, garage or outhouse belonging to and used with a dwelling. And it doesn't appear that there is any degree of permanence required. It may be a temporary dwelling. So the extent to which the tunnel goes underneath that wouldn't be covered by this offence. There's a reasonable excuse defence, which includes, it's not limited to this, but it includes if the person with an interest in land authorised it. It's 12 months on summary conviction, but it's either way. So there is the option for it to be heard on trial on indictment and to be heard by a jury. The second part of this is not creating the tunnel, but being present in the tunnel after the section came into force, or entering after the section came into force, if that presence causes or is capable of causing serious disruption, and you intend or are reckless as to that consequence. That part of it also has a reasonable excuse defence along similar lines. It's also either way, with 12 months in the magistrate's court, 3 years in the Crown Court. And again, linked to it going equipped for tunnelling, having an item which may be used in the course of a tunnelling offence, with the intention that it is summary only and 6 months. Then there's the obstruction of major transport works or obstruction of key national infrastructure. So these are, again, as we see here, nothing new, obstructing airports, road building, energy, oil, things like that. It is an offence to obstruct the undertaker, and any wrestling fans there will see the undertaker. Unfortunately, it's not him. It is a person authorised by Parliament, or where development is under the Planning Act of 2008, a person constructing or maintaining those works, which is much less fun. Or a person acting on the authority of the undertaker, who is setting out the lines, constructing major transport works, taking steps reasonably necessary for construction or maintenance of major transport works. And it's also an offence to interfere with, move or remove apparatus relating to the construction or maintenance of any major transport works. So there's already some legislation which you'd have thought covers this, but it perhaps remains to be seen to what extent this will be used instead. There is again a reasonable excuse defence, and that includes if the act was wholly or mainly part of a trade dispute. It's summary only, and the maximum sentence is 6 months. Key national infrastructure is similar sort of setup. It's an offence to interfere with, which includes delaying, significant delay being caused to key national infrastructure if one intends or is reckless to that happening. Key national infrastructure is defined in the Act. It's broadly defined. Each of these sections has their own subsection specifying what they mean. Air transport includes all listed airports and so on. And the newspaper printing infrastructure, for example, is specifically defined. It includes magazines and periodicals as well as newspapers. There is also a reasonable excuse defence. Again, if it's in the course of a trade dispute, there being separate legislation dealing with picketing and trade disputes. It's either way, but whether it's in the Crown Court or the Magistrates Court, the maximum sentence is 12 months. So that's a very quick run through of the legislation if it comes into being. And I think we'll deal with questions on that aspect of it at the end. Thank you very much.
Thank you very much, Tom. I should have said in introducing Tom that he's also one of the authors of the Protest Handbook, which I thoroughly recommend both to anyone who is a practitioner in this field, but also anyone who's involved in protest and from the activist point of view. So that's my plug for Tom's excellent book. Our next speaker is another barrister from Garden Court Chambers, Elena Papamichael. Elena is a criminal practitioner who was formerly a specialist criminal defence solicitor. She has a wide-ranging practice covering a lot of serious crime, also modern slavery, but has a specialisation in public order and protest cases where she's represented in a significant number of recent cases. She was the solicitor in the Colston 4 case, and since working as a barrister has also worked on BLM and anti-fracking protests. She has written, and her work has been reported in the Times and the Guardian, including writing about the topic that similar to what Jude was explaining about criminal behaviour orders and their intrusions on fundamental rights. Elena is going to speak on a very important aspect of this legislation, which is the stop and search powers. Unbelievably, they're both powers based on suspicion and being suspicionless, which I think is probably a new concept in the criminal and indeed in any law. And that's what she's going to talk about now. Thank you very much.
All right, so I'm going to talk about the proposals to expand stop and search under the Public Order Bill. I just wanted to share with you a quote, which isn't on my new slides, on my old slides, but essentially Priti Patel has said, what we've seen in recent years is a rise in criminal, disruptive and self-defeating guerrilla tactics carried out by a selfish few in the name of protest. This bill backs the police to take proactive action and prevent such disruption happening in the first place. These measures stand up for the responsible majority, and it's time that Parliament got behind them. Well, we've heard, as Tom rightly points out, that these so-called guerrilla tactics are not new, and perhaps what is new is a rising intolerance of protest, and the proposed expansion of stop and search is likely designed and will have an effect on cooling protest. Can anyone see my slides at the moment? No. All right, and I'm just going ahead without them. All right. Well, what we have essentially is the bill provides for both a suspicion-led power and a suspicion-less power. And the suspicion-led power essentially aims to amend Section 1 of PACE, the Police and Criminal Evidence Act, which is the main power that the police currently use where they are required to have reasonable grounds to search someone in a public place. But as the power currently stands, it's relatively limited, at least in comparison to what the proposed amendments are. So just quickly, Section 1 entitles officers to search people or vehicles where they have reasonable grounds, either to find stolen items or prohibited articles. And prohibited articles is a fairly limited list, which I was going to say includes, but actually the entire list of definition of prohibited articles is offensive weapons, bladed articles, corrosive substances, fireworks that contravene the fireworks regulations, and then articles made or adapted for use or in connection with burglary, theft, or taking a motor vehicle without consent, fraud, or criminal damage. So a fairly narrow definition at present of what a prohibited article is. Under clause 9, the bill proposes to add a range of offences to which the definition of a prohibited article would apply, being any article, in the similar wording of the Act as it already is, any article made or adapted to use or in connection with, and essentially, this is where the slides would be handy, each of the offences that Tom has gone through with us today. So the offences of locking on, causing serious disruption by tunnelling, causing serious disruption by presence in a tunnel, obstruction of major transport networks, interference with use or operation of key national infrastructure, and then in addition to that, an offence under Section 78 of the Police Crime Sentencing and Courts Act 2022, and the new offence of intentionally or recklessly causing public nuisance, and the offence of an obstruction of the highway under Section 137 of the Highways Act 1980, where it involves activity which will cause or is capable of causing serious disruption to two or more individuals or an organisation. So suddenly, if this bill is passed, the police, as long as they have reasonable suspicion that you are carrying an article for made or adapted for use or in connection with any of those offences, then they would be entitled to stop and search any individual in a public place or a vehicle. And so we can just imagine how wide that is, and the articles that are spring to mind are household or everyday items such as bike locks, super glue, duct tape, but also importantly, anyone potentially on their way to a protest, a mass protest, potentially could be now subject to a stop and search under the proposed amendments. And so it massively increases the scope of the police's main power to stop and search, and it would leave pretty much anyone attending a demonstration vulnerable to being stop and searched. And so we then go back to what I said at the beginning, and that this really is designed to deter people from attending demonstrations, full stop, in my view. It gets worse. Clause 10 provides for a power to stop and search without suspicion. And so it means that where this is enforced, officers are entitled to search people or vehicles for, again, an object made or adapted or intended for use in the course of connection with those specified protest-related offences that I've referred to, without having to justify having any reasonable grounds to do so at all. So it's a carte blanche to just search anybody in a specified locality for a specified period. And they do not have to have any grounds for suspecting that person or the vehicle is carrying such object. There are criteria. Subsection 1 provides that it has to be an officer of rank of inspector to give authorization, and he has to reasonably believe that any of the offences that we've talked about may be committed in a locality within his or her police force area, or that persons would be carrying prohibited objects, as we've talked about, in the locality or within the force area. Subsections 10(3) and 4 provide that if the further condition is met, then that power can be exercised for 24 hours. And that condition is that the senior police officer who gives the authorization believes that the authorization is necessary to prevent the commission of offences within section 1A, so the protest-related offences, or the carrying of prohibited objects, those that are made or adapted or in connection of for use with those offences. The specified locality has to be no greater than necessary, and the specified period must be no longer than necessary. So that gives the police the power to impose that for a block 24 hours, and the police can apply to extend that for another 24 hours if an officer of rank of superintendent or above believes that it's necessary for the same reasons as subsection 4, so necessary to prevent the commission of offences or the carrying of prohibited objects. And that power allows any constable in uniform to stop any person and search them or anything carried by them for a prohibited object, and to stop any vehicle and search any vehicle, its driver or passenger for a prohibited object. And they can do that. Subsections 10(7) and 8 specify whether or not the constable has any grounds for suspecting that the person or vehicle is carrying such a prohibited object. And subsection 8 provides that if an officer finds an item which they have reasonable grounds to suspect is a prohibited object, they can seize it. And so obviously many of you will already be thinking that this has significant parallels with section 60 stop and search power, and in fact the government has explicitly drawn that parallel and confirmed that the framework mirrors the section 60 framework. It's worth noting that as controversial as section 60 is, I will come on to, the justification for such a serious infringement on civil liberties is that there is the prospect of serious violence, or there has been serious violence, or a serious or a dangerous instrument or offensive weapon has been used in a locality. And we're now essentially widening the ambit of that extremely invasive power for a wide range of protest-related offences, which is shocking in itself. We also know that section 60 has been widely criticised, both for its efficacy, and it's worth noting that only 4% of searches under section 60 result in an arrest, and only 1% of those result in an arrest for what the search was for, i.e. weapons, in the case of section 60. So many of those arrests, which add to the already very low arrest rate, will be for offences arising out of the search itself, and possibly low-level drug offences, amongst others. We also know that the section 60 search power has been, again, widely criticised and acknowledged in official statistics as being used in a racist way, in an ethnically profiling way, with black people being 18 times more likely to be searched than white people. So the normal search powers under section 23 of the Misuse of Drugs Act and section 1 are also used disproportionately against black people and other ethnic minorities. But with section 60, that is grossly exaggerated. And so it's disappointing whether the government has made noises about scaling back section 60 in light of how unfairly and it's used. this government now proposes to expand it quite significantly. Section or clause 13 creates a new offence where somebody obstructs a constable exercising the new section 60 power, the search without reasonable grounds under section 10. I've set out the penalties for that, but I won't go into that. Section 11 or clause 7 provides for the procedural requirements or more procedural requirements, as well as the criteria that need to be complied with in order for the search to be lawful. So I can anticipate that there would be arguments similar to an obstruction of an officer under section 89 of the Police Act, where an alleged offence is committed of an obstruction, but where the police haven't complied with either the criteria or the procedural requirements. Clause 12 briefly just sets out the entitlement to a search record as long as it's applied for within 12 months. And that's it really. The driver's similarly entitled to a search power, a search record. So I know we're running over time, so that's it essentially.
Thank you very much, Ellen. Sorry we had the difficulty with your slide. So I think we're now going to move to our final speaker, who's Kevin Blowe. As you know, Kevin works for Netpol. He's been the campaigns coordinator since 2021. He has been active in community-based police monitoring initiatives since the 1990s and has most recently worked on monitoring of the policing of anti-fracking groups and protesters and bringing to light and exposing the oppressive nature of those policing, the use of surveillance and targeting of protesters. He is also the author or co-author of Restricting Rebellion, Netpol's report on policing of the Extinction Rebellion protests in London 2019. And he's going to now talk something about the wider context. Thanks, Kevin.
Thanks very much. And thank you to all the speakers. It's been really, really helpful. I wanted to set out why and how we reached the point that we're at now in relation to protests causing disruption. And as Stephanie mentioned, the starting point for me is the issue that has suddenly returned to the political agenda in the recent weeks, that question of local consent for fracking. So Netpol worked with community campaigners opposed to fracking from 2013 till 2019. And let me tell you, those campaigners did everything the system expected of them. They used the democratic and planning processes to challenge fracking. And in Lancashire, they won, only to see all their efforts overturned and overruled by central government. And then, to their shock and surprise, local people faced years of demonisation, oppressive policing, constant arrests for continuing to oppose the fracking industry, the onshore oil and gas industry that have essentially been imposed on them. And their experience is part of a pattern of what we've seen over the last decade, the gradual hollowing out of our democratic institutions, a refusal by governments to listen to critical voices or to differing views. And instead, we have this default position for ministers now of denouncing anybody who disagrees with them as the enemy. The latest example, directors we saw with the Liz Truss speech last week towards the previously unknown anti-growth coalition. So it's no wonder, given that that's where we are, so many people have reached the conclusion that to prevent the destruction of their communities, to resist industries that fuel the climate emergency, to stop the inhuman treatment of asylum seekers on so many different issues, all we have left is disruption. It's the only way that we can get the government to listen. And in fact, we've reached the point, I saw this over the weekend, but even the Royal Society for the Protection of Birds is talking about direct action, which is extraordinary. Faced with what senior police officers believe, I suspect quite rightly, is the growing probability of more disruption in the future, particularly around the environment and the climate emergency. The police's role in all of this has been to lobby the government for more powers to maintain order and protect property. The proposals that became the recent Police Crime Sentencing and Courts Act originated from that lobbying by the leadership of British policing. And I think it's important, and I know I've seen this in the comments, that we see the current public order bill as essentially that act's unfinished business. The impetus to protect the property interests of businesses is why the bill places such an emphasis on national infrastructure. But as Jude set out, the most alarming part of the bill in many ways is the proposals for the serious disruption prevention orders. The idea is enormously draconian, and as Jill, as was pointed out at some length, it's very, very vaguely worded. Now, we know in 2019 that there was a protest roundtable organised with senior officers and government officials, and the Home Office said that the police had identified, let me just quote this, circa 30 environmental activists who travel the country orchestrating protests and taking direct action. They are the likely targets for these new banning orders. A relatively small number initially of non-violent protesters, although the number we think is most likely to grow, is most likely to have grown since then, is likely to grow again in the future. We don't know exactly how many, because the police say it will cost too much money to provide Netpol with the number of people categorised as so-called aggravated activists, the likely target of these banning orders. But to build a case for bringing them in, for getting an order imposed, officers will need to seek, they will need to gather intelligence on hundreds of people involved in the movements their targets are part of, on the people that they know, on the places that they work, even if they personally have never committed any kind of unlawful activity. So the public order bill means a massive increase in police surveillance, on top of intelligence gathering that's already expanded by recent new legislation. Now, unfortunately, Stephanie mentioned this at the beginning, the lesson from the enormous effort that went in to try and stop and amend the Police Crime Sentencing and Courts Act is a sobering one. The public order bill is likely to become law. But none of that means the protest has yet been made illegal. But it certainly has become a lot more uncertain. And for Netpol, that means that as campaigners and as movements, and certainly for the excellent work that the lawyers do in supporting them, we need to create the conditions that challenge the spread of that uncertainty. And we argue that that can be done in 4 ways. Firstly, by making sure that everybody knows their rights, because put simply, knowing what powers the police have gives people enormous confidence to challenge their misuse on the streets. By resisting police surveillance, so that means better protection for the members of our movements most likely to face the kind of targeting that I talked about, and a greater awareness of the basic security practices that can help us to challenge police intelligence gathering. By offering more practical solidarity, so we need to get much better at not seeing ourselves in isolation for other campaigns, and understanding that the threat of oppressive policing is going to fall on all of us at some point. So we better start offering solidarity to each other. And finally, unsurprisingly, given the work that Netpol does, it means actively monitoring what is happening around the country. So Netpol needs to know when new powers are being used, so that we can use that information to demonstrate how we think they are being used to actively disrupt and further criminalize the right to dissent, because that, in a way, is the most effective way for us to be able to challenge the introduction of further legislation of new powers. Right? One of the things that we discovered in the course of the Police Crime Sentencing and Courts Act is the police have no idea how often they use Section 12 and Section 14 powers to impose restrictions on protest. And we don't think that the case has been properly made for the public order bill. So in terms of how we go about doing that monitoring, we are asking for people's help. We have set up an encrypted monitoring form. We've got a phone number for people to be able to send information to us via Telegram or Signal. And certainly there's a lot more information available on our website. You can find more in particular at netpol.org/defending-dissent. Or you can just Google defending dissent and Netpol's name. The reason for we do this work, and the reason why we try and highlight these issues, and the reason why it's important that people understand what potentially might be coming down the line, is that if we don't resist the use of the powers ourselves, the police will feel confident to use them. And that's why we're urging everybody to support our work in defence of the right to dissent, to understand what's coming, potentially coming down the line, and make sure that that not just individually, but as groups and as movements, we are properly briefed on how we organise that resistance. I'll leave it there.
Thank you very much, Kevin. It may just follow up. I just noticed in the chat that someone has posted that on the 5th of November at 12 o'clock, there's a national demonstration. I don't know if it's against this bill. Maybe the person in the chat could say that. But if there is a protest, then obviously use that right before we are about to, on the face of it, look like we might lose it. So if we could just, there are some questions that we've got in the question and answers. There was, and the first one reflected some other comments in the chat as well, which is about the role of photographers and whether they are also at risk, and whether they face having their equipment taken from them. So I don't know whether, again, it's obviously like legal observers, accountability for what happens on protests is important. Photographers being able to do their role may be important in documenting abuse. I don't know if anyone's got a view on whether they're going to be caught. Tom, if you could answer that.
I was just going to mention about the legal observers, because I think that's a topic which at some point might be subject to a report by the UN Special Rapporteur on Freedom of Assembly, and they've looked at the role and the fact that certainly in the UK there isn't a formalised recognition of the role of legal observers, and that they are in need of protection. So I think in the meantime, then there's certainly a case to be argued that by attending to make sure the police don't overreach their powers and to document what's going on, that is not causing or contributing to someone else carrying out an activity likely to cause serious disruption. And I thought the same could be said for photographers. Now, obviously, the fact that there's an argument to be made for it doesn't mean people won't get arrested for it and it gets sorted out at a later stage. But I think that I'd be very surprised, I would hope, if there were convictions for people who were acting as legal observers or photographers. So I think there's, I think even with this broadly drafted legislation, that would be a stretch, or it should be.
Thank you. Another question that we had was about the position of trade unionists and people on strike and the overlap between picketing and protests, and whether protests were going to be, whether picketing was going to be covered by this. I think, Tom, you explained there were some carve-outs, but more generally, do we think these powers could be used to address strike action?
I mean, I think the answer is it depends on who it is that's organising it. So one of the things that, in particular, some of the unions that organise around precarious workers, so people like United Voices of the World and others who are not formally recognised as unions by, for instance, hospitals and so on, their way of being able to raise the issues quite often is to organise a protest outside of a workplace. And we've seen examples before where the police have then used restrictions on their ability to be able to protest as though they're just, a group of demonstrators rather than trade unionists engaged in a dispute. And that's always going to be possible. It's certainly possible under the provisions of the Police Crime Sentencing and Courts Act. And I would imagine that, if the Public Order Bill becomes an act, that will apply too. I mean, the difficulty is that what the police should do and what they actually do on the streets quite often are two completely different things, which touches on the previous question about photographers and legal observers, of course. So technically speaking, they're not participants in a demonstration, but that doesn't matter if the police decide they're going to move you on. And certainly we would say for trade unions, and particularly those trade unions who are, organising workers in a sort of non-traditional way of a formal dispute, that they need to be making sure they understand what their rights are. I mean, we've seen people arrested for picket lines from major unions, and I think it seems likely that it depends on the dispute that the police will make those decisions based on circumstances on the ground.
Yeah. I mean, I would obviously the provisions about noisy protest, you could see how they could be used, and why wouldn't they make a distinction if it happens to be within the context of picketing outside of a business or an institution or organization. There's every reason to think they might use it. So, and there always has been a symbiotic relationship between the provisions that limit trade union activity and those that are used to regulate protests, usually the other way. So the measures that are in the Trade Union Act are often used, for example, in injunctions to prevent things like besetting, some ancient sorts of torts that have been used against picketing. So there is a symbiosis between legislation directed at one group being used against the other, and I think it could definitely be vice versa. There's one other question that's issue that's raised a number of times, is about another bill going through Parliament, the National Security Bill, and how this might also interrelate with these measures, because it focuses on potentially on protest around the arms industry and has very high sentences. So I don't know, again, if that's something that people have thought about, how these two pieces of legislation might interrelate.
There is a very hopefully useful post on our website that I'll try and find and share about the national security, but it does raise particular concerns for peace activists outside of military bases. Rather than go into it in detail, because it is quite involved, I'll find the piece and drop it into the chat.
Thanks very much, Kevin. And then we have one other other question about the bill introducing the potential power for the Secretary of State to apply for injunctions. And there's a question about whether that might get removed by the House of Lords. Kevin, you may be able to comment on this. When you talked about fracking, one of the measures that was used against anti-fracking protests was an attempt to bring very wide-ranging draconian injunctions, with many of the measures that are now either in the Police Act or in this bill. And certainly, I think the context of the High Court and the Court of Appeal kicking out a lot of the measures that was brought within persons unknown injunctions is also part of the background to this. So it is interesting that now the government is seeking expressly to have a power to apply for injunctions. And again, I don't know if that's something that that is on anybody's radar about how that might be used, because on the face of it, there's plenty of power to seek injunctions through other bodies at the moment.
Well, I think, I mean, one of the things, there are an extraordinary number of injunctions in place at the moment. I mean, every Shell garage currently has an injunction imposed on it. There is major injunctions on most of the national road network. I think the reason why the government is wanting to put this in is because it's not stopping people from protesting, and that there are certain groups who have been prepared to face the prospect of going back to court and facing a contempt of court charge, because they feel that the defence, particularly around raising issues around the climate crisis, is more important than the consequences for that. But in a way, all of the legislation that attempts to bring in new laws is about the government's failure and industry's failure to use injunctions as a way to stop people from protesting. And it's the classic thing: rather than engage with the issues, you try and stop the protesters from being able to raise them, and that isn't working. And that's the reason why, to a certain extent, the public order bill has been brought in, and why there may be more legislation down the line. Frankly, that's always a possibility too. But I don't know if there's anything more particularly I can say about injunctions other than they're not working. That's why the government wants to bring in new statutory offences.
I don't know if anyone else wants to comment on that.
No, could I just pick up on one comment in the chat? It might be a nice point to finish on, as I know we're coming up to 7 o'clock. But someone commented that obviously the risk with educating your fellow protesters is doing it in a way which doesn't scare them off, which is absolutely right. And it's really, really important that people aren't scared off, because that's really what the government wants to do. They want to create this chilling effect so that people don't go out and hold them to account. But it's really important that we do. I mean, it's shown in the fact that these are serious disruption prevention orders, and protest is supposed to cause disruption. It's supposed to interfere with people's space so that they are aware of the issue that is being protested about. The right to protest only peacefully and inoffensively is a right not worth having. So it is really important, and it is important, and I think perhaps some helpful advice I've always found representing protesters is that most people I represent have a good instinct as to what is right, and what when the police are overstepping the bounds of what they're allowed to do, and when people are exercising their right to free speech. And that's something that when cases do come to court, if they do come to court, that we will always be there to fight for, and to ensure that those rights are available for everybody. And there are challenges that can be made to this legislation if it goes through in its current form. I've mentioned the reasonable excuse provisions, the right to free speech. I've mentioned, Jude was talking about the serious disruption prevention orders. And although there isn't any sort of mental element attached, I think the courts will in due course add that in. Because if someone unwittingly contributes to another person carrying out an activity likely to cause serious disruption and gets an order for it, there's no way that the higher courts would countenance that. It cannot be necessary and proportionate for that to happen. And so there are ways that these can be challenged, and it will take some time. And my view is the same as with the Police Crime Sentencing and Courts Act, that in due course, there probably won't be too much of that left on the statute, but whether it be through legislative change, through a change of government, or whether it's through public pressure to have those removed, or whether it's the courts interpreting it down so that it doesn't have as much of an impact as this current government intends. There are ways for this to be challenged, but it probably won't be quick. It will take some time, and there is a fight ahead. The best way, I think, as I said to someone in the chat, is to make sure this doesn't come in the first place, because things like tunnelling, it's going to be very difficult for any future government to say we're going to legalise tunnelling in order that causes serious disruption. It's going to be much easier to stop it getting on the books in the first place. And so, as Steph's just said, if there are protests against this, then we need to exercise that right while we still can.
Yeah, I would just like to add as a final thing that people will be frightened by this, but the way to deal with that fear, and it echoes partly what Tom said and also Kevin, got to be better organised. Just one example would be around photographers and legal observers, that, there might have been times when the legal observing cohort might have been perhaps not fully organised, perhaps not everybody had jackets on, perhaps there wasn't a list of people, etc., etc. So, there are ways round whatever attack is coming. People have to be better organised, even more informed of their rights, and continue the fight. And, if people are together and working with lawyers, working with each other, then there will be a way of fighting all this.
Well, I think that is a very good note to end this very interesting and concerning, disturbing seminar. I think we understand how challenging this piece of legislation is for our fundamental rights. But as everybody has said, we do have fundamental rights. They are enshrined in the Human Rights Act. They are there in the common law, and it is our ability to use those rights effectively, and to defend it, whether it is on the street or in the court, that will be the best measure of how much impact this legislation actually has in practice. I wish you all happy protesting, because there's plenty to protest about.